Welcome to you next officer. Hope you're doing good. So today I am with a different question where you need to use different approach to attempt this answer. As usual, just to remind you, our target is to produce 250-word answer within 10 minutes so that we can get some 7 half or 8 marks out of 15 within 10 minutes so that we can spare some time for next question as well. As the question today reads, analyze. Analyze is the keyword here. Analyze the necessity for state-led surveillance with existing constitutional and legal provisions. Also, it's asking about the changes needed. Without wasting time, let's get into the topic. So, whenever it comes to surveillance, what are instruments that could be used? Maybe phone tapping, which could be called interception of telecom lines in technical terms, that a communication engineer or communication department would call it. Other than that, maybe CCTV cameras and other means of monitoring. This is how state would carry out its surveillance. So any surveillance that would be carried out by state is state surveillance. So how to introduce this? If nothing strikes to your mind, you can bring some novel elements like uh, George Orwell's 1984, written in 1948, out of which the today's concept of Big Boss has been carved out of. George Orwell's 1984 brought the concept of Big Brothers actually. Then that Big Brothers was emulated in India with the Big Boss, etc. So hope you can relate the things with what happens there. So you can introduce that way and make a soft transition, speaking about what could be a hurdle. That hurdle will create commodification, commodification of personal data, right? So other than commodification, you also find other problems where state can blackmail. I mean, when I say state, it's not the state, but the people who misuse are in the power. So people who misuse the law and the kind of power that has been bestowed in them, if channelized in wrong way, could be used to blackmail a common representative of people. For example, someone who is in the ruling cabinet can direct CBI or other surveillance agencies to blackmail the people in opposition and ensure they ask less questions that pertain to public interest and be safe, at least accountability. So these things would lead to, and even with surveillance, state would like to peek into private life, which leads to totalitarianism, right? Totalitarianism. So these are some hurdles that we discuss. Then we would go into what we call as body. In body, we speak about, as the question asks, about constitutional provisions and legal provisions. You can use your creativity, how you represent it, maybe in a tree diagram or a flowchart, something else. But as far as the content is concerned, what all things you need to write, if you ask me, Article 19, I mean, specifically speaking, Article 19(1)(a), the very first part of it is violated, as the surveillance will, or the blackmailing or monitoring will give you chilling effect. When I say chilling effect, you will be in a feel, it's not due to temperature, but the chilling effect will make you feel your brain is constrained in fear that if I speak something else or express something, it might lead to unnecessary consequences that state would impose on me. So that fear will prevent us from being freely expressive. So that is a hurdle to Article 19(1)(a). Also, with the Puttaswamy judgment, it is violation of right to privacy. And today, right to privacy after Puttaswamy judgment, you can mention it as Puttaswamy versus Union of India. Sorry, this is not legal. Even this is constitutional provision. So under constitutional provision, one is Article 19(1)(a) and other one is Article 21, which covers right to privacy. So privacy concerns, no one can peek in your personal life to know about intimacy, etc. Okay, so these are constitutional provisions. Now, what about legal provisions? So under legal provisions, we have two acts. One is legacy of Telegraph Act, which is called as Indian Telegraph Act. It is, I'm calling it I'm calling it legacy because it is more of what we call as a act that was made during British time. So it is definitely a legacy act. Other than that, other than Indian Telegraph Act, we have IT Act of 2000 and guidelines to interpret them, which came in 2009. IT Act. So there is a kind of opaqueness in these acts. So these are some legal provisions that are available. But what is necessity of state surveillance? If you ask me, the main purpose is to procure the information about the non-state actors who can pose threat and be prepared. You need to be prepared well in hand to have advantage over them. Second thing, you could also mention that in conditions of health hazards or health emergencies where the pandemic would spread, you can choose to take disciplinary action to ensure discipline of social distancing. So, especially a kind of discipline, but discipline should not be at cost of what we call as right to life or right to freedom of expression. So that all that we need to see is the power is not misused with unreasonable restrictions. How to know whether they are reasonable or not? You need to have accountability. The accountability should be fixed by Parliament. So, having said that, you can call about a committee where secretaries of three departments, because the question of law is existing here, the question of IT infrastructure for interception of data exists. So you can call IT secretary, and however, it is also part of home department as some kind of policing is involved in what we call as surveillance. So these people could take decision on case by case basis and be accountable to parliamentary committees, because it's not cabinet that has ultimate sovereignty, but a parliament. So parliamentary committees can fix accountability for that. You need what do you need? You need all the executive institutions. When I say executive institutions, institutions made out of executive order and not having statutory backup are to be accountable to parliamentary committees for every act they would take. And on this note, we could actually end with the proper conclusion, which would fetch a lot of advantage. And in conclusion, it would be great if you mention about minimum non-personal approach, which was mentioned by Sri Krishna Committee. Justice Sri Krishna has produced the draft report for data privacy in 2019, and for last 2 years it's not been touched properly. Minimum non-personal approach, where you'd only touch the data that is required, that too only when if it is necessary. So minimum non-personal approach of dealing with data would actually fix responsibility of data fiduciaries. Who are fiduciaries? Those people who are responsible for maintaining the database of your personal data or non-personal data even. Fiduciaries. Okay. Now, I think we have discussed enough about how to be written and what to be written. Let's go back to look at how the answer would look like if we do this. Starting with the mentioning of George Orwell's novel of 1984 written in 1948, the earliest prospectus of predicting a surveillance state may be traced back to George Orwell. So the state surveillance, which translates to interception, monitoring, and decryption under the veil of secrecy. So if it is done under the veil of secrecy, interception, monitoring, and decryption would translate to threat to state's interest and its surveillance parties. And it is not new today. It's not a new phenomena to use it for political purposes, but if it is linked to proliferation of digital data, poses new challenges. What are those challenges? First is, as we discussed, commodification of personal data. That would lead to surveillance capitalism. You may quote example of Cambridge Analytica. Okay, now you can mention about controlling human nature, that leads to breach of privacy. The commodification of data would lead to human nature controlling with blackmailing, and finally a totalitarian order of development as endpoint. Hope you remember what we were discussing 10 minutes ago. The state provisions for guaranteeing against surveillance is what we discussed about Article 19(1)(a), how the freedom of speech and expression is compromised by having chilling effect, and which hinders the very act of freedom of speech and expression. And we also discussed about the Puttaswamy judgment, where Puttaswamy versus Union of India judgment provided us right to privacy under Article 21. So this brings a picture of gross infringement of Article 21 if the surveillance is not a reasonable. Okay. Having said this, we need to mention legal provisions as well, as the question asks about constitutional and legal provisions as well. I would call it legal protection instead of provision, because those are not just provisions but the protections given. We have legacy of Indian Telegraph Act for interception of telecommunication lines. When we say telecommunication lines, it can be a phone tapping or even any interception of or decryption of your messaging apps like WhatsApp or other place where they claim to be having end-to-end encryption. If that is decrypted, then again it's under Indian Telegraph Act as you're intercepting telecommunication lines. And as I was also mentioning about opaqueness of Section 69 of Indian IT Act and Interpretation Rules of 2009, let me just elaborate here because the Section 69 says the Section 69 is primarily mentioning about putting surveillance or ban on even surveillance or ban on any data providers or any individual in national interest. The very term of national interest is very vague that it can be arbitrarily used. So now it would be injustice if we don't mention the need for surveillance, at least in minimum amount. So we are here to mention it as we discussed to procure and plan against non-state actors. Surveillance helps forces with preparedness. So we'll be having advantage if we know well in advance and also in fixing disciplinary way to address health crisis, which may be aided by much needed surveillance. Hope you understand as I've explained it 10 minutes ago. So now the main purpose of changes that if any needed in state-led surveillance is to check the arbitrariness and disproportionate amount of executive authoritarianism. The problem is with executive authoritarianism, the solution is to process. The solution is to follow the due process of law. And those paths that we traverse while following due process of law should be in a way that, as we were discussing about it, involves some policing and some utilization of ICT tools and question of law. We need a committee of Home Secretary, IT Secretary, and Law Secretary approving for every interception of data and also to be accountable for their actions. If you look at other suggestion that we are mentioning in the answer, many agencies with National Investigation Agency being exception, except that many of the surveillance agencies are created out of executive order. Those are not by parliament but executive order. So making them accountable to parliamentary committees would check a repeated misuse of provisions. As we were mentioning that parliament is more sovereign than cabinet. Parliamentary committees have every power to fix the accountability. In way forward, we would say about minimum non-personal data approach that was mentioned by Justice Sri Krishna Committee on data privacy bill. So that has to be implemented to fix the responsibility of data fiduciary. For that, we need a data protection bill. If passed, may allow parliamentary committees to fix accountability of investigating agencies. On this note, I think within last 20 minutes I've explained how to produce better answer within the time frame for 250 words with the keyword analyze, especially when asked about the security or surveillance questions where you need to be careful not to bring any political angle and be neutral in your views, but actively mention suggestions and loopholes that are being misused. Till the time I meet you next, hope you have utilized this 20 minutes to enrich your knowledge and also learn something about the approach of answer writing. So I'll be back with a new question where I would produce a new approach and better answer. Till then, bye bye.